right, everybody, let's get started. My name is Megan Russell. I am a partner in the Toronto office, and I am one of the partners in the employment group. Happy to bring you today the 5th Dentons Canada COVID-19 employment webinar. During today's webinar, we are going to provide you with another update in terms of what has transpired in the last week. We are going to be talking about some privacy issues. We're going to be talking about some health and safety issues with respect to temperature screening. And of course, we will be answering many of the questions that were posed during last week's webinar session last Friday. If you have further questions following this webinar, of course, feel free to reach out to a member of our Dentons employment team. So first, just a few housekeeping issues or items. Once you have logged on to the webinar, you should be able to hear and see the meeting and the PowerPoint slides. Please remember to turn on your computer speakers. Attendees to this webinar can go online, of course, for additional national and global COVID-19 related information, including using our global tracker and our provincial updates, which we continue to post daily, if not near daily, as the updates continue to come in from the various levels of government. For accreditation purposes, please note that this session is eligible for 1 substantive hour with the Law Society of Ontario and the Law Society of British Columbia. We have also submitted an application for eligibility to the Bureau du Québec, which is pending. The presentation, the PowerPoint slides that you should see up on your screen are available for download on Adobe Connect today, and an email will be sent to all registrants on Monday with the recording and the materials from today. Further, we have created an Insights page on our Dentons website that has all of the employment and labor webinar series recordings and materials. So the previous 4, both PowerPoint presentations and recordings are up, and as of Monday, this session will be up as well. First, a quick note on the federal wage subsidy. We are patiently waiting for the legislation to pass and receive royal assent. And when that happens, we will be issuing a publication covering the final details as soon as that occurs. Next, a very, very important update from this week. As many of you likely know, various provincial governments have deemed the Easter Bunny to be an essential service. So for all of you with children or those of you who simply love Cadbury mini eggs, rest assured the Easter Bunny will be coming this weekend. So with that, I will introduce our speakers. First, you'll hear from Roxana Jangi, Senior Associate in our Calgary office. She will be speaking and providing an update on the amendments to the Employment Standards Code in Alberta. Next, you'll hear from Kirsten Thompson, partner in our Toronto office and privacy expert. She will be discussing privacy implications of disclosing an employee's positive diagnosis for COVID-19. Next, you'll hear from Chelsea Rasmussen, Senior Associate in our Toronto office. She will be speaking on employee temperature screening. And then the remainder of the webinar will be left to cover those questions that we received last week. So following those updates, you'll hear from Roxana, Chelsea, and Craig Lawrence, a partner in our Toronto office, who will answer those questions. So with that, Roxana, over to you.
Good morning, everyone. Megan, thanks for the introduction. So in the next little bit, as Megan mentioned, I will be providing a high-level overview of the temporary amendments made to the Employment Standards Code in Alberta, which were announced by the government this past Monday on April 6th, 2020. So to jump right in, one of the amendments that were made by the government was the introduction of a new leave provision under the Employment Standards Code, which is effective as of March 17th, 2020. Specifically, the government introduced an unpaid job-protected leave for employees who are unable to work because they are caring for their children affected by the school and daycare closures, or who require time off to care for family members who are under quarantine. The length of the leave is flexible, and the duration will be linked to the guidance provided from the Chief Medical Officer of Alberta. Unlike some leave provisions under the Employment Standards Code, the employee does not need to be employed by the employer for 90 days, nor does the employee have to provide a medical note to be eligible for the leave. Now, while a medical note is not required, the Order in Council outlining the amendments does set out that an employer may require an employee who takes this leave to provide the employer with documentation reasonable in the circumstances and at times reasonable. Now, what this generally means for all employers is that during the leave period, employees are generally protected from termination and layoff, and they must be reinstated after the leave unless operations are discontinued or suspended or one of the exemptions apply under the Employment Standards Code. Another amendment that has been introduced are temporary amendments to the layoff provisions, which might come as a relief to many employers who, in response to the COVID crisis and the economic crisis, have engaged in or are considering engaging in temporary layoffs to reduce their payroll burden. Normally, under usual circumstances, unless certain conditions are met under the code in Alberta, once an employee has been temporarily laid off for a period of 60 days within a 120-day period, the layoff will crystallize into a termination, and termination pay will be due to the employee. Now, the government has temporarily extended the 60-day period such that the layoff will not crystallize into a termination unless the employee has been laid off for 120 consecutive days. Employers are not required to continue benefits or wages or provide employee wages during this period of time. However, it should be noted that if an employer does continue wages, benefits, or provides an amount instead of wages, then they could extend the layoff period in Alberta until such time as the employer ceases to continue to make payments towards benefits, wages, or an amount instead of wages, provided they have the agreement of the employee. So this change is retroactive and applies to all temporary layoffs that occurred on or after March 17th, 2020. Now, the latest change to the temporary layoff schemes are extremely helpful as it improves the likelihood that employers will be in a position to recall workers before the temporary layoff period ends, and it will also help employers keep their workforces relatively intact. Now, just as a further point to this, we've discussed this in our previous presentations over the past couple of weeks in quite some details, but employers should note that temporary layoffs, even when sanctioned by the Employment Standards Code, can still potentially amount to constructive dismissal if the employment agreement does not contemplate that the employer may lay off employees. However, as noted previously, given the current circumstances around COVID-19, the court closures, and where employees are recalled within a short period of time, the risks associated with such claims are minimized. If you would like more information specifically on this point, we do encourage you to contact your Dentons lawyer. So in addition to the layoff provisions, amendments have also been made. Provisions have also been made to group termination provisions under the Employment Standards Act. For those of you who may not be familiar with these provisions, employers generally, in normal circumstances, are required to provide advance notice to the Minister of Labour, their union, if applicable, and if they have one, and any affected employee, where the employer intends to terminate the employment of 50 or more employees at one location within a 4-week period. Now, the length of notice under group termination provisions are generally greater than the minimum notice requirements for individuals and generally depend on how many employees are being terminated. So, for example, in Alberta, employers are required to give employees 8 weeks notice regardless of their years of service if they're 50 or more, but fewer than 100 employees who will be terminated within a 4-week period at a single location. That notice period increases to 12 weeks if there are 100 or more, but fewer than 300 affected employees, and then further increases to 16 weeks if there are 300 or more affected employees who will be terminated at a single location within a 4-week period. Now, under the temporary amendments, the government is waiving the requirement for employers to provide group notice of termination to affected employees and unions. Employers are still required to provide notice to the Minister of Labour and Immigration as soon as practical in the circumstances. The notice to the minister must be in writing and must set out the number of employees whose employment will be terminated, as well as the effective date of the termination. Further, it should be noted that group termination provisions do not apply to terminations relating to employees who are employed on a seasonal basis and for a definitive term or task. So in addition to those changes, there have been changes to scheduling requirements. Again, under regular circumstances, Section 17, subsection 2 of the Employment Standards Code requires employers to provide employees at least 24 hours notice of a change to their schedule shift, effective immediately, subject to terms of an employment contract or a collective agreement. Employers can now change an employee's shift time by providing written notice as soon as practical in the circumstances. So these changes are beneficial as they allow employers to more adequately respond to the changing demands of their businesses due to the COVID-19 crisis and more easily implement occupational health and safety measures such as physical distancing on their work sites by reducing the number of workers or staggering shifts. This provides a useful tool as well for employers to respond to the often abrupt changes in safety and operational needs impacting the workplace. There have also been changes to the scheduling requirements pertaining to averaging agreements. Under Section 13.33, subsection 1 of the code, employers are required to provide at least 2 weeks notice of a temporary change to an employee's work schedule where their schedule is subject to an averaging agreement. So this 2-week notification requirement is now temporarily waived, and notice will simply need to be given as soon as possible. This will be applicable to many employers, especially in Alberta's oil patch, who rely on hours of work averaging agreements as well, because this will provide much greater flexibility. We do caution employers they should still be mindful again of potentially collective agreements and employment contracts that may specifically speak to specific shift change requirements as well. So lastly, the final amendments that have been introduced are measures that will be streamlining approvals for modifying employment standards requirements through variances and exemptions related to COVID-19. Now, these changes are generally, what they've done is they generally allow variances and exemptions to be granted more quickly and in an effort to provide employers with greater flexibility to respond to the COVID-19 and the impact on the workplace. So that, in a nutshell, is a very high-level summary of the temporary new measures that have been introduced by the government that will be enforced moving forward for a limited time period. If you have any specific details, please feel free to reach out or send your questions in the Q&A, and we'll do our best to either respond to them in the shortcoming. So now, with that, I'll pass it on to the next presenter, Kristen to the next presenter. Thank you, everybody.
Hi there, my name is Kirsten Thompson. I'm a partner in the Toronto office, and I lead the Transformative Technologies and Data Strategy Group, which is a fancy way of saying privacy, cybersecurity, and things related to data. I'm going to discuss the privacy implications of disclosing an employee's positive diagnosis for COVID-19. Some of you will already have dealt with that, and I suspect many more of you will be dealing with this in the coming months. So, notwithstanding that we're in a pandemic situation, privacy laws still apply. The privacy commissioners of the various provinces and federally have all indicated that they will take a flexible and contextual approach to the application of privacy laws, but be mindful that they still continue to apply. And really, context is everything, so I'm going to discuss this in a few different contexts. The first context is the personal information that you have and handling it in a public health emergency context. So we have Canadian private sector, health sector, and public sector privacy laws, and they permit you to disclose personal information in two circumstances. One, when you have consent, and the other is when you have an exception to consent. And the exceptions are limited to those that are listed in the statute. Now, understand that these laws apply whether we're in a pandemic or not. So even if you were to do the ordinary course disclosure of personal information, these would still apply. If you're going to rely on exceptions to consent, which is most likely in these circumstances, you have to rely on one of the enumerated ones. Typically, it will be the disclosure of personal information in an emergency situation. But if you're looking at the slide, see those footnotes there. They're important because there's other exceptions that may apply. In provinces that have declared an emergency, there are often orders that suspend, modify, or invoke emergency or temporary legislation. You may be able to disclose information pursuant to those orders, which is an exception that you can rely on. You may be able to disclose it pursuant to the Quarantine Act, which is the federal, and some provinces have that, or as they modernized it, it's often called the Public Health Act. Note that the statutes use different language to frame these exceptions. Sometimes there has to be a threat to an individual. Sometimes it's a threat to public health. So read the statutes very closely if you're going to rely on these exceptions. Now let's assume we're going to rely on these exceptions. Typically these statutes require you to give a notice of disclosure, if you can, before the disclosure, if that's practical. If you can't do it before, then without delay afterwards. Now, if you're going to disclose and you're relying on either consent or an exception to consent, you still have obligations as an organization. You still have to only disclose or collect, use, and disclose the personal information that's reasonable and appropriate. So if you only need 2 pieces of information, you shouldn't be disclosing 37 different pieces of information. You have to limit it to what's necessary to achieve the purpose. If your purpose is to protect the health and safety of others, the information should be related only to that. You'll need to document this to comply with the accountability principle, and be open and transparent. And note that the privacy commissioners have just published guidance on that to say that if you are going to do this, you have to include the legislative authority you are relying on in order to disclose this. That's new-ish. It was previously considered a best practice. It's now been identified in the guidance as something you should be doing. So the second context we're going to talk about is the employment context. So the private sector privacy statutes do not require consent to collect, use, or disclose personal information that's directly related or solely used to manage the employment relationship. Each province sort of defines it differently. However, you have to have notified your employees that your personal information will or may be collected, used, or disclosed for those particular purposes. Typically, that's done in a notice or a privacy policy or that sort of thing. You may be justified in asking employers to disclose whether they've tested positive if it's necessary to fulfill the health and safety obligations that the employer has. And we've seen a lot of that around. It started with the sort of where have you traveled to, what are the recent travel, now it's contact with people. The trick here is what is necessary, and necessary will vary depending upon what the employer's health and safety obligations are or what's happening with public health authorities. So pay close attention to that as well. There are also limits on this. You should not be disclosing reasons for an employee's leave except to those employees that need that information. Remember here that the objective is to allow potentially exposed coworkers to take with sufficient knowledge that they can take steps to protect themselves. You shouldn't be over-disclosing. And you've got to take some reasonable efforts not to identify the individual, either expressly or implicitly, and that's sometimes tricky. It's a bit of a balancing act. In some cases, that may be impossible. If you don't think you can do it without specifically identifying the individual, you may want to give your Dentons lawyer a call just to navigate that. And so now let's talk about the security context of these sorts of disclosures and the handling of this type of information. Employers have always had an obligation to have reasonable safeguards in place to protect information, but we're kind of in a perfect storm right now. Employers are finding that they are handling much more sensitive information, in other words, health information related to COVID, and that their information security measures are being challenged by all the stuff that they've done to get their entire workforce working remotely. Often these remote security safeguards aren't necessarily as robust as the ones that were in the office. So what organizations need to do is think about the physical, technical, and administrative controls. Just because you're out of the office doesn't necessarily mean that these shouldn't apply. So think about the working from home context. For instance, if you have personal information that's now on portable devices, you may have to require authentication. You have to look at encryption. If you've got everybody working out of the office, secure VPNs, multi-factor authentication. We've all, I'm sure, seen notices about the increased phishing and fraud risk. Supplement your privacy training with tips and hints to make it contextual to the home environment. Also, and this one's overlooked, consider how remote working will impact your ability to implement business continuity plans, data incident response, that kind of thing. I was just working on an incident. It was a data breach where everybody went to reach for their very good data incident response plan and realized they couldn't contact each other because nobody had their cell phone numbers. And then this last piece I put in here simply because I've seen a spike in this. Most of you will have left your regular premises, storefronts, retail, whatever those premises are. You probably left things behind. Those things probably include personal information. Break-ins, smash and grab theft are on the increase. I've been working with a number of clients who are now dealing with breach reports and management because they've lost personal information in this old-fashioned, old-school kind of way. So just be mindful of that. Lock everything up. And I will now turn this over to my colleague Chelsea, who is going to talk about temperature screening.
Thanks, Kirsten. So as Kirsten said, my name is Chelsea Rasmussen, and I am a senior associate in the Toronto Employment Group. So today I'll be talking about the question of whether it is legally permissible to take the temperature of employees using a thermometer at the start of each workday. And this is a question we've received from many clients in recent days. So in answering this question, there are human rights, occupational health and safety, and privacy considerations that come into play. So generally speaking, medical examinations or health-related tests like temperature taking are generally acceptable only if the testing or examination is reasonably necessary to confirm the potential employee's ability to perform a bona fide occupational requirement of the role. So that means the bona fide occupational requirement means like that certain skill or ability that's required on a good faith basis in order to do the job. It is generally not permissible to require that all employees undergo a health-related test, such as taking temperatures, because that constitutes an invasive action. It would be more acceptable to test individuals on a case-by-case basis, where an employer has reasonable cause to require a particular employee to have his or her temperature checked. For example, there's some reasonable belief that that employee should be in quarantine. However, as you've undoubtedly heard over the past few weeks and in our Dentons webinars, under Canadian occupational health and safety legislation, employers have an overarching obligation to take every precaution reasonable in the circumstances for the protection of their workers. As such, in our view, COVID-19 may be sufficiently serious to allow for a departure from this general rule that health-related tests are impermissible for all employees. So I'll briefly take you through our view on temperature screening and the legal permissibility of that in Ontario, Quebec, Alberta, and BC, and then we'll provide you with some practical tools if you do decide to implement such screening. So in Ontario and in Quebec, there is no legislation or case law authority that is directly on point at this time that makes temperature screening legally permissible. However, as I indicated, employers do have obligations for protecting workers' health and safety on the job under health and safety legislation. So in our view, in Ontario and Quebec, where businesses continue to operate and an employer's obligation to take all reasonable precautions for the protection of the health and safety likely justifies temperature screening in these COVID circumstances. That said, it is important that the temperature taking process be as minimally invasive as possible. On the question of human rights infringement, the Ontario Human Rights Commission has actually issued a policy position, and they say that using temperature screening to verify or determine an employee's fitness to perform on-the-job duties may be permissible under the code in the circumstances of COVID-19. However, information on medical tests may have an adverse impact on employees with other disabilities. And they also say that employers should only obtain information from medical testing that is reasonably necessary to the employee's fitness to perform on the job, and any restrictions that limit this ability while excluding information that may identify a disability. In addition, the Ontario Ministry of Health has issued guidance for industry operators, and in that guidance, the Ministry of Health suggested that facilities may consider temperature checks to monitor for fever over 35 degrees Celsius and advise the employees to immediately self-isolate if symptoms develop. So while this isn't any sort of explicit authorization that temperature screening is legally permissible, it shows that the Ontario Ministry of Health considers that temperature screening is a potentially effective measure in slowing the spread of COVID-19. So to sum up for Ontario and Quebec, in our view, the crisis likely justifies employers who are still open in taking these more drastic measures to ensure that not only the health and safety of their employees, but also of any customers if they're continuing to interact with the public. But it is important to have appropriate controls and measures in place, and I'll speak to those controls and measures at the end. So moving on to Alberta and British Columbia. Both Alberta and British Columbia have a Personal Information Protection Act, and they are virtually identical in respect of this question. So I'll deal with these two provinces together. So the PIPA puts limits on employee screening, and it requires that where collecting personal information, employers collect only the personal information that is minimally necessary to be collected, and to do so in the least intrusive way. Further, under PIPA, organizations should not collect, use, or disclose personal information unless it is for the purposes that a reasonable person would consider appropriate in the circumstances. So in this current COVID context, the reasonableness of requiring temperature checks will depend on factors such as whether the tests are reliable insofar as indicating someone may or may not have COVID-19, whether health authorities have recommended or recognized temperature checks as an effective screening method, whether the checks are carried out in the least intrusive manner possible, for example, having a third party collect that information as opposed to the employee's supervisor, a professional third party, I should say, and whether there are less intrusive ways of accomplishing the same goals, the sensitivity of the personal information, and whether it's really necessary to impose blanket screening of all employees versus screening of certain individuals for particular factors. For example, if they're working closer to other employees or their duties suggest an enhanced caution is required. So to sum up, in BC and Alberta, temperature screening can be legally permissible if the employer can demonstrate that it meets this reasonableness test. Importantly, though, we would note that unless there is a scientific basis for requiring such screening, it's likely difficult to justify the collection of such personal information from a privacy standpoint. So keeping in mind what we just discussed, I'll now take you through some suggested best practices for temperature screening. In terms of practical implementation, in our view, any temperature screening of employees must be voluntary in the sense that an employer can't force employees to have their temperature checked. However, given the information from public health agencies, the scope of the pandemic, and the spread of the virus, in our view, and if an employee refuses to submit to that health check, an employer can then refuse to permit access to the workplace. So first and foremost, as a best practice, we want to ensure the dignity of the individual being screened. So making sure that everybody is treated equally and is free from discrimination. Second, we recommend conducting the screening in conjunction with other active screening measures. And so those other active screening measures include instructing employees to self-monitor for symptoms such as fever, cough, or difficulty breathing, and to not come in if they're experiencing those symptoms. It also includes, upon arrival at the workplace, asking your employees if they have been experiencing any of the known symptoms of COVID, asking if they have traveled outside of Canada in the last 14 days, have they been in close contact with someone who has tested positive or who has symptoms or who has recently traveled outside of Canada. Another measure you could consider taking is asking the employee to take their temperature themselves at home before coming in, so they realize that really they shouldn't be coming into the workplace. So these active screening measures used in conjunction with temperature screening is helpful because, as we know, the temperature screening and checking of fevers in the workplace may not be 100% reliable. Also, the employee might be asymptomatic, so they don't have a fever, but these other questions could potentially catch a potential case. And lastly, we know that fever isn't the only symptom of COVID. Third, we suggest conducting the screening in a private manner, ensuring that results cannot be overheard, and keeping results in the strictest confidence. So as we just heard from Kirsten, it's very important to protect employees' personal information, so I won't go into any more than that. For number 4, ensure that the individual conducting the screening has appropriate personal protective equipment. And number 5, ensure physical distancing throughout the screening process. So that's both during the screening itself and while individuals are waiting to be screened. So both points 4 and 5 require you to consider the method and the process for testing. On the method of testing, will you be using an in-ear thermometer that requires you to get a bit closer, the individual screening to get closer, or a handheld non-contact thermometer? And then after you consider that, on the process for testing, you need to take into account the safety considerations during the screening. So will the individual who's administering the test be coming into close contact less than 2 meters with several individuals? Does the individual administering the screening then have personal protective equipment to ensure their safety, including by requiring them to wear gloves, a gown, mask, eye protection, face shield? Is there hand sanitizer at the station? Thinking of all those sorts of things. And then lastly, if you've got a bunch of employees starting the shift at the same time, ensuring if they're waiting in line to be tested, are there markers on the ground to make sure they're standing at least 2 meters apart or other controls in place to ensure that people are practicing safe physical distancing while this process is taking place? And lastly, on the best practices list, we suggest setting a threshold temperature for the screening that's objective and that is medically supported, and also that is consistently applied to all individuals. So you set your threshold temperature using medical guidance, and then any employee who exceeds that threshold should be immediately asked to return home and to call their local public health agency for further instructions. And then you can also inform them that the company will follow up with them. So to summarize, while there's no explicit legal authorization for temperature screening, in our view, given our new reality with COVID, it may be sufficiently serious to justify that employers who continue to operate engage in this process as long as appropriate procedures and controls are implemented. And with that, I'll pass it back to Megan for the Q&A portion.
Thanks, Chelsea. So first question is for you, stemming from last week's webinar and in relation to OC health and safety. So the first question is, are we as employers at risk if we send an employee to work and they contract COVID-19? Secondary question, can we be sued?
Thanks, Megan. Yes, another common question that we've seen over this crisis. So I've said it before, I'll say it again. Employers have an obligation to take all reasonable precaution in the circumstances to protect the health and safety of their employees under occupational health and safety legislation. But I will say, if your business falls within the government's list of essential businesses that are permitted to continue operating, then you are able to continue operating and to assign work to your workers as long as the workers aren't engaging in any sort of work refusal. In terms of whether you can be sued if an employee contracts COVID-19 in the workplace, generally speaking, where an employer has coverage from the Workplace Safety and Insurance Board, they're not able to sue their employer for an injury or an illness contracted in the workplace. However, in terms of potential consequences, if an employee contracts COVID-19 in the workplace, The Ministry of Labor does have the power to lay tickets against an employer or to prosecute an employer under the Occupational Health and Safety Act if the employer fails to comply with the obligations of the legislation, which again includes taking all reasonable precautions. So we recommend in the circumstances, if your employees are continuing to go to work and you ensure that everybody, both employers and employees, are strictly following all of the public health guidelines in respect of hygiene and physical distancing, and complying with these recommended steps set out by public health and other resources is helpful not only to prevent the spread of COVID-19, which is obviously the primary goal, but also it shows that the company is trying to take every precaution reasonable in the circumstances. And so keeping up and adapting as we get more information is important to ensure that you're taking all the steps that you can to protect your employees. So again, that includes, controlling access to the work site, active screening of employees, and ensuring physical distancing, cleanliness, appropriate PPE is available, and listening to any employee concerns that they raise and trying to remedy them to the extent possible.
Great, thanks, Chelsea. We're going to turn to the topic of layoffs. A couple questions here. Actually, Chelsea, we'll start with you on the layoff topic. In Ontario, can the temporary layoff period serve as a termination notice if the temporary layoff converts to a permanent layoff?
Good question. Unfortunately, no. A temporary layoff cannot serve as a termination notice if it converts to a permanent layoff. The temporary layoff period is intended to be just that. It's intended to be temporary. And under the ESA, employers are required to give notice of termination in writing. So not notice of temporary layoff, but notice of termination in writing. And also the common law actually states that employees are required to be given an effective date of termination in order for that to be valid. Also, I would note that during a notice of termination period, employees are usually entitled to the pay that they would have otherwise received, which is not something that they're receiving while they're on layoff, so it wouldn't count as, notice.
Great, thanks, Chelsea. Next question is for Roxana. In Ontario and Alberta, can an employer pay into an employee's healthcare spending account, which they can use to purchase health or other insurance, during the layoff in order to extend the layoff period?
So I can speak from an Alberta perspective. Section 63, one of the Employment Standards Code, does contemplate that the layoff period can be extended with the agreement of the employee if the employer pays wages or an amount instead of wages, or alternatively makes payments for the benefit of the laid-off employee in accordance with a pension, employee insurance plan, or a similar plan. In our view, health spending paramount would likely fall into potentially the category of a similar plan under the Act, and could potentially also act to increase the layoff period. So yes, it is possible in Alberta potentially to extend the layoff period.
Okay, great.
Yeah.
All right, go ahead.
Oh, no, that's good. Go ahead.
Okay. Second question for you, Roxana. Do you anticipate that there could be changes to what is permitted in terms of the length of temporary layoffs in Alberta based on these unprecedented events?
So so again, we can't predict things with certainty, but the government, as mentioned earlier in their presentation, has already amended the layoff period from 60 days within a 120-day period to 120 consecutive days. So that has already occurred in Alberta. With respect to other jurisdictions, I think it'll highly be dependable on the situation as it unravels. We are aware Manitoba has made recent amendments as well, extending the layoff period effective March 1st, where in Manitoba potentially any layoff period since March 1st will not be counted towards the calculation of the layoff period until the state of emergency has been lifted. So I do think it's quite possible that other jurisdictions may follow suit, but I do think it's highly circumstantial and it's a bit of a wait-and-see game to see how the governments respond to the situation.
Great, thank you. So over to Craig. Question for you. If there is no clause in the employment contract, but the employee is in agreement, can we obtain written agreement for the temporary layoff to occur?
Yeah, so we've been getting this question a fair amount because there are a number of employment agreements that simply don't contemplate temporary layoffs. And I think we've all seen various employee side lawyers write op-eds in newspapers and do podcasts speaking about how laying people off in the absence of a temporary layoff provision can constitute a constructive dismissal. So the reality is, yes, you can enter an agreement with your employee to take a temporary layoff. The question would be the same as it is in any contract amendment situation, which is, was there fresh consideration provided in exchange for that change to the existing terms? So have you provided them something? Have you put a sub-plan in place in exchange for them agreeing to a temporary layoff? Has there been some sort of benefit that has flowed to them that would make that agreement enforceable? Because absent fresh consideration, there's really nothing to stop the employee from agreeing now, but then subsequently, when the economy recovers, commencing a claim against the company and claiming that they only agreed to the layoff because they were under economic duress. So our advice is typically, yes, you can make that agreement, but you should try to provide some consideration in order to make it enforceable down the road.
Great, thanks, Craig. All right, Chelsea, back over to you. Again, we're on the topic of layoff. Regarding the temporary layoff option of up to 35 weeks in Ontario, if an employee pays a portion of the employee's benefits, would this continue for the 35-week temporary layoff? Or put another way, would this permit the payment of a portion of benefits an employer to lay off up to 35 weeks?
Yeah, so employees are expected to continue their portion of the benefits of the temporary layoff period of up to 35 weeks if that's what was in place immediately prior to the layoff. So if they had a copay, the expectation is that they continue that. The question often arises is, what if the employee doesn't pay their portion? And then as a result, the insurer suspends or cancels their plan. Does that still mean that the layoff up to 35 weeks will qualify as a temporary layoff? So the Ministry of Labor has issued guidance on this point, and the guidance is that the layoff will still be considered temporary, even if the employee does not make its co-payments, which results in the plan insurer suspending or canceling the plan. However, the Ministry of Labor policy is also that the employer should do everything reasonably possible to ensure continued coverage for that employee. So whether that's taking advantage of any sort of grace period with the insurer, and also importantly, the employer should be contacting the employee to ensure that their failure to pay wasn't an error, lost mail, or just due to an oversight they forgot to send the premium. So there is some obligation on the employer to try to help the employee out before relying on the employee's non-payment.
Okay, great. And a secondary question for you, Chelsea. For a layoff in excess of up to 13 weeks in Ontario, so 13 weeks in Ontario, could benefits be satisfied by the continuation of the employee assistance program, but not other benefits such as health, medical, or pension?
Yeah, so if an employer would like the temporary layoff to last up to 35 weeks, the Ministry of Labor guidance is that the employer has to continue all group or employee insurance plans that were in place immediately prior to the layoff. So if the employer continues only part of the insurance, then the layoff will not be considered temporary after the 13 weeks. It's important to note, though, that a number of insurance policies do provide that certain benefits won't be continued after a certain number of weeks, and that's part of the plan terms. A lot of times that's disability benefits. The insurer says it will only continue for 26 weeks, for example. So in that case, where the requirement is that the employer must continue all of the benefits, If the employer isn't able to continue all of the benefits through no fault of their own, because it was the plan terms, not the employer's choice, then that doesn't affect the temporary layoff period. Again, though, there's the caveat, the Ministry of Labor guidance, where if the insurer, again, prohibits the continued coverage because of plan terms, the employee should ask the insurer to continue the coverage, and they should also check to see if they could arrange alternate coverage somewhere else and with another insurer. However unlikely that may be, the Ministry of Labor guidance suggests that the employer take these steps, ask if they can continue the disability benefits if that's what it is, and if not, see if they can obtain coverage elsewhere. This Ministry of Labor guidance, it's not law, but it does show how the Ministry of Labor will handle the issue, so it's worth listening to.
Great. Thank you, Chelsea. All right, Craig, over to you to talk about sub-plans. So the first question is, given that EI applications will now be processed through CERB or CERB, are employers still able to provide employees with sub-top-ups, which would otherwise be available if they were receiving regular EI benefits?
Right. So this is another good question, and one that we've been receiving from a number of clients. And there isn't clarity on this yet from the government as to how CERB benefits will interact with existing or new subplans. So as some of you will probably be familiar, every subplan under existing rules has to state that payments are predicated upon the employees being in receipt of employment insurance benefits, and their receipt of those benefits is confirmed by a report that's generated by Service Canada itself. So those are typically required components of a subplan, and they don't contemplate CERB benefits replacing EI benefits. So you kind of have two different streams of thought here, one being that it's simply a legislative gap and that at some point the government will turn its mind to it. The Prime Minister on Tuesday did make reference to the fact that CERB is going to be expanded to include employees who have seen a reduction in hours as opposed to simply the elimination of work altogether. So if the government is turning its mind to expanding CERB to include more people, you would reasonably expect that it will also address how CERB will interact with subplans, because there's no principled reason or policy reason why subpayments should not be provided while an employee is in receipt of CERB benefits as opposed to EI. So hopefully that legislative gap gets filled. The strict reading of the law right now would suggest that subplan payments don't apply to CERB benefits, and that because every application post March 15th defaults into CERB, your subplan payments, just like your EI benefits, won't kick in until the exhaustion of your CERB benefits at the end of the 16-week period. But again, there's no principled reason why that would make any real sense right now, and we do expect the government to address this. I will say there are a number of examples where clients and companies have taken the position that they've made a promise of making subplan payments in exchange for the temporary layoff itself, and they are prepared to proceed despite the gap in legislation right now. So there is a risk, but we expect it's one that should be solved in relatively short order by the government.
Great. Thank you, Craig. Roxana, over to you. Talking about the CERB or CERB benefit, will the CERB be taxable? Roxanne, in the event that you are still on the line and you are speaking, I think you might need to just unmute quickly because we weren't able to hear you there.
Hi, sorry about that. So again, based on the information available from the government to date, the benefit is taxable, although the tax will not be, it's our understanding that the tax will not be deducted at source. So employees will be expected to report the benefit as income when they file their income tax returns for the 2020 tax year.
All right, thank you. Another question for you, Roxana, based on a client question that came in during last week's webinar. If an employee applies for the CERB or CERB and later for EI, after exhausting the 16-week CURB eligibility, it should work, right? As in, the employee will be able to apply for EI after the exhaustion of the CURB benefit.
Yes, absolutely. So they would still be able to access their normal EI benefits provided that they are eligible if they're still unemployed after the 16-week period covered by the CERB. Absolutely.
Great, thank you. Okay, Chelsea, over to you. We're going to switch gears and answer some questions now on the federal wage subsidy, keeping in mind my comment when we started, which was, the legislation has not yet passed, has not yet received royal assent. We keep seeing in the news, that the legislation is being worked on and updated. So our answers are current to today at 12:54, and to the extent that we need to supplement later, we will. So the first question under the federal wage subsidy, Chelsea, is if some team members are on paid vacation, would that be included in the actual wages calculation?
Thanks, Megan. So from what we know at this point from the government, eligible remuneration may include salary, wages, and other remuneration. So that's the term, salary, wages, and other remuneration. So these are amounts for which employers would generally be required to withhold or deduct amounts and remit them to the CRA for the employee's income tax obligation. We would note that it doesn't include severance pay or items such as stock option benefits. So if some team members are on paid vacation, we expect that would be included in the actual wages calculation. However, we do, as Megan said, have to wait for the draft legislation to see how they define salary, wages, and other remuneration before we could say definitively.
Okay, thanks, Chelsea. Another question for you. Is there any further guidance as to what is a pre-crisis level of remuneration?
So a bit of an answer on this one, yes. There was, in yesterday's announcement, the government clarified the meaning of pre-crisis remuneration as follows. They said, the pre-crisis remuneration for a given employee will be based on the average weekly remuneration paid between January 1 and March 15 inclusively, excluding any 7-day periods in respect of which the employee did not receive remuneration. So it's between January 1 and March 15th, excluding any 7-day periods in which they didn't receive remuneration. And that's all the clarification we have at this point.
Okay, thanks, Chelsea. One last question for you. In terms of independent contractors, are they excluded from the definition of employees for purposes of the federal wage subsidy? And if so, is there any program coming to subsidize the amount paid to them to avoid having to terminate those independent contractor agreements and having to then go on to the CERB?
So given the usual way that independent contractors are treated, as well as what we know so far in terms of how the remuneration of employees is being calculated, we can expect that independent contractors won't be included in the definition of employees and therefore won't qualify for a subsidy under this program. But again, we would have to wait for the draft legislation to confirm this point. I know the question mentioned the CERB. It is available for self-employed individuals who would not otherwise be eligible for EI, but we're not aware at this time of any other pending programs that would, otherwise subsidize the amounts paid to independent contractors. And given that, the CERB does, allocate funds to self-employed individuals, it might be that that's all the only benefit, but again, we can't say with certainty.
Okay, great. Thank you, Chelsea. Over to Craig, I suppose for the last 2 or so questions to wrap up the webinar. Craig, are there any benefits currently for people whose hours are reduced?
Right, so this is a question that is getting a little more clarity even this week. As I said earlier, the Prime Minister on Tuesday said that they're looking at expanding CERB to be available for employees who experience a reduction in hours. So we will keep our eyes on what that looks like next week. So that's option number 1. The second option has existed, for years and years, which is work share, and obviously that would contemplate a reduction of between 10 and 60% of someone's work, and the balance being covered by EI. That's the second bucket. They have streamlined that process quite significantly. You no longer have to have, a recovery plan. The eligibility criteria have been significantly lessened. So work share has become a much more viable option, even if you have to have a reduction of hours. Then the third bucket is little used, but nevertheless, it's worthwhile if you're thinking of a nominal reduction, and that's working while on EI. So there is a framework under the existing system that says you can keep 50% of every dollar you earn. You just have to report what your earnings are while you're collecting EI. So you can't work a full week, but there is still an option that someone could potentially collect EI while working on a reduced hour schedule. So those are kind of your three options. One will be the expansion of CERB, the second being work share, and then the third being working while on EI. They all kind of have their own pros and cons, and it usually requires some specifics to identify which one's best.
Okay, thanks, Craig. One more question for you. If a company can prove that revenue has been down for the month of May, but cannot prove the same for the months of March or April, just due to the nature of the business, how long will the government subsidize for? The whole 12 weeks starting in March, or only for that period in May?
Yeah, so it's periodic payments, so your eligibility can change depending on the period that you're applying for. So even though under the changes that they're proposing, your comparisons might be slightly different, particularly if you're a startup, it doesn't mean that when you show losses in May, you now get retroactive benefits to March or to April, to the prior periods. It has to relate to the actual period that you're applying for.
All right, excellent. Thank you very much. I see that we are at time to end our 12 to 1 o'clock webinar. Just like to thank everybody again for joining us. We do see that there's been lots of questions that have come in over the last hour. We will again be hosting another webinar in a week's time or so next Friday, and we will endeavor to answer these questions as well next week. So stay tuned for the invitation for that webinar. Also stay tuned for upcoming publications, again on updates on the federal wage subsidy. We will do our best to continue to keep everybody informed. So thank you to everybody. I hope everybody has a lovely, safe and healthy long weekend, and hopefully we will see you next week for the next webinar. Thank you so much, and thank you to our speakers. Bye-bye.